Welcome back to the Constitution Line by Line. I'm Paul Fabrizio.
And I'm Don Frazier, and we're still plowing our way through Article 3, which is about the establishment of the judicial branch of our government.
Right, and we've just established where that jurisdiction lies for federal courts.
Yeah, so they've spent a lot of time establishing jurisdictions.
And now we're going to talk about something that we've mentioned before, which is original and appellate jurisdiction.
Okay, so this is actually then Article 3, Section 2, Clause 2. Because all that other stuff we've talked A through G before was all still Clause 1, just compound clause.
Yes. So, in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both to law and fact, with such exceptions and under such regulations as the Congress shall make. So
Congress has a role here.
Congress has a role. Congress can pass a law prohibiting the Supreme Court from hearing a case, a specific type of case. Okay. And in fact, they've done it at least once.
What was it?
I don't know. This fine book we're using here mentions a case in 1868 in which the court was in the process of deciding it, and Congress stepped in, withdrawing the court's jurisdiction in that particular type of case.
I might add that was during Congressional Reconstruction.
Yeah,
when there was all sorts of hijinks going on at the hands of Congress.
Yeah, the timing is suspicious.
The timing is suspicious. That'd be interesting to see what that case was. All right, anyhow.
But what we've got here is we talked about the district courts, and they have original jurisdiction. That's where cases start.
Yeah.
Losers appeal to the Court of Appeals, and that's the appellate courts, so they only hear appeals.
Okay.
Losers appeal to the Supreme Court, so they have appellate jurisdiction, and that's what this talked about. But this also gives them original jurisdiction for certain types of cases.
Yeah.
And as it says here, cases involving ambassadors, other public ministers and councils, and those in which a state should be a party, the Supreme Court shall have original jurisdiction. The reality is when you look at the Supreme Court, 99% of its cases are appellate cases.
Yeah.
And
cases on appeal.
Cases on appeal. So in other words, the losers appeal to the Supreme Court. And there's 1% of the cases, very, very rare, where it would be an original jurisdiction.
There's going to be some coming. There's going to be somebody versus state of Alabama over their recent passage of fairly restrictive abortion laws.
Yeah, but those would be appellate cases.
So you think those would be appellate?
The first step in that would be to go to the district court. And a district court judge is required to follow precedent, Roe versus Wade being the established precedent.
Sure.
And that judge, if he's following the rules, should declare the Alabama law unconstitutional.
Okay.
And then Alabama would appeal to the Court of Appeals. The Court of Appeals should then follow precedent and rule against Alabama as well. Then Alabama would appeal to the Supreme Court.
Okay.
And the question then would be...
So the Supreme Court would not be the original jurisdiction?
No, the Supreme Court would not be the original jurisdiction, as it says in cases involving ambassadors, other public ministers and councils, and those in which a state shall be a party. My understanding is that sometimes boundary disputes between states might start at the Supreme Court, but I'm not sure about all the particulars. I have seen Supreme Court decisions where the Supreme Court sits there and in the decision and has a map and plots out with the longitude and latitude, the degrees and the minutes of boundaries, where they appoint a special master, often a retired judge or justice, to sit there and actually plot out where the boundary is going to be to resolve these kind of disputes that come before.
Okay, so that's an example of original jurisdiction.
And the reality is it's a really rare thing. I mean, the Supreme Court in a typical year might only have 70 cases.
Yeah.
And so,
if you run your ratios there's not one of them that's an original jurisdiction.
Yeah, exactly. So this is a rare thing, as it should be.
Yeah, absolutely. These guys don't need to be on the front line.
Right.
They need to be contemplative.
Yes.
All right, so back to that appellate court. Mm-hmm. So we've got a original court here in Abilene, gorgeous courtroom, etc.
Yeah.
Where is the court that you would appeal a federal case?
The closest one, we would be under the jurisdiction of the Fifth Circuit Court of Appeals. That's in New Orleans.
Okay.
All the courts of appeals cover several states.
Sure.
And so we're simply covered by the Court of Appeals for the Fifth Circuit. Do you know why they're called the circuit, by the way?
I'm assuming that the judges had to go from location to location.
Yeah, circuit riders.
Yeah, they had to ride a circuit.
Yeah.
Or travel a circuit in order to hear all the cases.
Yeah.
Now that I'm sure they will assume that you will go to New Orleans.
Right. And so that's the way it is. But the original idea was you divide the country into these circuits. And originally, and this is another reason why justices hated to be on the Supreme Court originally, in addition to the fact there was nothing to do, they also served as those courts of appeals, and they would drive their horses around and run the circuit.
Wow.
And so they would spend 6 months on the road, and think of what the road was like back in 1800.
The road.
Yeah. And they would hear cases that people had lost in district courts. Not
yikes.
a fun thing at all.
Yuck.
So the New York Supreme Court for John Jay
looks so much
this
better.
Is cool.
Yeah, I just get to hang out in Albany or New York or wherever it was.
Yeah. So anyway, the original and appellate jurisdiction is, basic part of the court system and the Supreme Court.
All right, so that's that.
Yes.
All right, so that's our line. We'll pick up the next line. Is this another part of the same clause?
It sure is.
So it's part B?
3.
No, so it's clause 3.
Clause 3.
All right, so we'll
misunderstood your question.
That'll be the next line next time. Thanks.